Okay, well, good afternoon. Welcome to the first seminar of our fourth season of seminars on legal philosophy between state and transnationalism, sponsored by the Nathanson Centre, and really is the one seminar that we have here at York that embraces both philosophy and law in one context. So we have representatives from the Department of Philosophy, many professors and students from both faculties, so we're very happy to have you with us. And today, well, we have a speaker who, in fact, needs no introduction. So without further ado, Professor David Lubin is with us from Georgetown Law School, where he's university professor and professor of law and philosophy, as well as, I think that's still the case, acting director of the Center on National Security and Law. Professor Lubin holds a BA from the University of Chicago, as well as a PhD in philosophy from Yale University. He has been a visiting professor at multiple institutions, including the Yale Law School, as well as Stanford Law School, Dartmouth College, the University of Melbourne, Harvard Law School, and more recently, the Hebrew University in Jerusalem. In addition to legal ethics and philosophy, for which you may know Professor Lubin, his recent scholarship concerns international criminal law, just war theory, and human rights, as well as the U.S. torture debate. His presentation today really pertains to this, let's call it newer, although it's already very extensive portion of his scholarship, which focuses on risk-taking and force protection. And I must say that Professor Lubin is a risk-taker, as he managed to make it through the construction to get up to York today in one piece. Harnessing a civilian in the process, a friend.
Damaging him.
Oh, you didn't look too damaged, but we're very glad to have you with us. Professor Lubin has published over 150 articles and many books: Lawyers and Justice, Legal Modernism, Legal Ethics and Human Dignity, and most recently, International and Transnational Criminal Law with two other authors. As a respondent today, we have our very own Dan Priel, who is one of the new additions to our faculty here at Osgoode Hall Law School. Prior to that, Danny was an assistant professor at the University of Warwick in the UK. And prior to that, from 2005 to 2007, he was a fellow in law at Yale Law School. And before that, a postgraduate student at Oxford, where we met and became friends. He served as a law clerk on the Israeli Supreme Court. He was the co-editor of the Law Journal at the Hebrew University. And his current research interests include many things: legal theory, private law, especially tort law and restitution, as well as legal history, and the application of the social sciences, in particular psychology, to legal research. And his work has appeared in countless journals, and he's a famous colleague of ours. So without further ado, Professor Lubin will take the floor. Our format is very simple. We typically give the speaker about 35 minutes to make a presentation. The paper has been circulated in advance, but we don't assume that people have read it. And Professor Priel will follow with a response of about 10 to 15 minutes, and we'll then give a short opportunity to Professor Lubin to reply, and then the seminar will be, we'll open the questions to everybody until 4:30, where we have to vacate this room. Professor Lubin.
Okay, hi, well, thank you. It's really great to be here. I was here, I can't remember, maybe 4 years ago for the Wallenberg Human Rights Symposium. I see that there's that you have an obstructed view seat. And can you see past the coffee machine? Because if not, I'm going to try to solve the collective action problem and ask everybody to shift left so that she is not stuck behind the coffee machine. Okay. Okay, where does this go?
Tie high up.
High up.
There we go.
Okay.
You can hide this onto, or leave it on the table if it's too cumbersome.
Okay. And I gather that a number of you are here from a torts class. Is that right?
Just me.
Oh, just you. Okay. Okay, so I won't bend over backwards trying to tie this into the topic of torts, although there is a fairly natural connection that comes up. The question that I'm dealing with is a pretty straightforward and I think gut level one, and that is, must soldiers take risks to avoid unintentionally killing civilians? And in particular, suppose that the answer is yes. So really two questions, therefore. Do they have to take the same risk to minimize casualties among the enemy's civilians that they would take if it was the Army's own civilians that were in this jeopardized battle space? Now, this has become a subject of a recent, I would say academic debate, but it's been more of a media debate between academics, between a paper by Asa Kasher and Amos Yadlin. Kasher is one of the leading military ethicists in Israel, and Yadlin was the chief of the general staff on one side, and the philosophers Avishai Margalit and Michael Walzer on the other. Michael Walzer is the author of the 1977 classic Just and Unjust Wars, and is more or less attributed, the revival of just war theory in the 20th century is often attributed to Walzer. And I should explain that I wrote this paper originally as a contribution to a book called Reading Walzer, which will appear in the fullness of time. Now, the Kasher and Yadlin view was pretty stark. It is this. Protecting innocent civilians in our territory, that means our own civilians, but also if we have occupied a country, people who, under our effective control, so civilians in our territory, is a higher priority for soldiers than protecting themselves. So they think that soldiers do have to take risks for civilians. But protecting our soldiers is a higher priority than protecting their, meaning the enemy's, civilians outside of our territory. So you can you don't have to take, if you're a soldier, you don't have to take as much risk to avoid the enemy's civilians becoming collateral damage as you would if it was your own civilians. Now, that's their side of the argument. Margalit and Walzer's response is that that's the wrong distinction. The distinction that should be operating is not between their civilians and our civilians, but simply between combatants and non-combatants. The moral obligation of soldiers is never to target non-combatants and to minimize so much as is possible unintended injury to non-combatants. And that's the same for all non-combatants. It doesn't matter who they are. They don't come with nationality stickers on them. Now, I am wading in this debate and defending the Walzer and Margalit side. Let me set this up by looking at an argument of Walzer's. He considers one of the basic moral principles in thinking about the morality of war to be the doctrine of double effect. The doctrine of double effect is, of course, a wide-ranging moral principle. It also plays a role in medical ethics and in many other subjects. And it says that as long as your intention is right, as long as you are not intending to target the non-combatant, I'll think of it in wartime terms, even if you foresee that there'll be civilian collateral damage in a legitimate attack, so long as that civilian collateral damage is not intended, then under certain conditions, it's morally excused and legally excused. And the basic legal condition that's attached to that is proportionality. But let's just think of it without getting into the fine points about proportionality, that sometimes you can knowingly harm another person, knowingly kill another person without being morally at fault if that's the foreseen but unintended byproduct of a permissible and justified action. That's the general form that different versions of the doctrine of double effect take. Now, Walzer, in Just and Unjust Wars, said there's a big difference between not intending that damage and intending not to inflict the damage. And he thinks that it's intending not to inflict it that is the morally relevant category. That, in other words, you have to actually take steps to avoid inflicting collateral damage. It's not enough that you simply didn't intend it, but that you have to go the extra mile to make sure that it doesn't happen. Otherwise, you would just have this tremendously dishonest mental game in which I am about to drop a bomb, and I know that there are civilians around, and I say, well, I get moral exculpation if I just narrow my intentions so that I'm only intending to hit the combatants, not the non-combatants. And then I go ahead and do what I was going to do anyway when I wasn't thinking about it at all, but now suddenly I'm morally off the hook. And the sense that Walzer conveys is that this is just a dishonest, disingenuous mental game unless you are actually taking tangible steps not to harm the civilians. He illustrates with a case from a diary of a soldier in World War I, a man named Frank Richards, who at one point was ordered, this was in France, to go around opening cellar doors and throw a hand grenade in case there were German soldiers hiding there. And Frank Richards was decided that before he did that, he had to call out a warning so that in case it was civilians that were hiding in the cellar and not German soldiers, that they could escape. And doing that, he was taking on extra risk to himself because if there were German soldiers inside, they could come out shooting when they heard him. And he would lose that element of surprise. And what Michael Walzer says is that this is not heroism. This is what any good soldier should do. This is not fighting heroically, but fighting well. It's what morality requires. This is what intending not might entail. So the main point that comes out of this kind of introductory spiel is that the intending not means taking extra steps to avoid harming the innocent, and that those extra steps might entail increasing risk to your own life. Now, one important intuition that's at work here is that innocent civilians, no matter who they are, really are innocent. Now, it may be that you think the opposite, that you think that the enemy's civilians aren't all that innocent. They support their own people, their own militants. They urge them on. They hate us. They'd like to see us all die and disappear from the earth. If they get hurt because they're in the battle space, well, tough, they had it coming. But of course, that's not right. In most cases, they aren't in the battle space because they want to be. And the fact that they hate us and cheerlead our enemy is that's not a death penalty crime. That is not a justification for killing them or killing their families. Okay, now, this problem of how much risk soldiers have to take to spare civilians becomes particularly intense in asymmetric wars in which the stronger side, let's think technologically sophisticated, well-trained modern army, has enormous latitude to pass on all the losses, if it wants, to the weaker side because it can use air power, it can use long-range artillery, it can use drones. Now, this asymmetry between the stronger and weaker side is a very old phenomenon from colonial wars. So, for example, the Battle of Omdurman in 1898, Great Britain versus the Sudanese, 48 British dead, 13,000 Sudanese dead. Blood River, this was the Boers versus the Zulus, 3 Boer casualties, 3,000 Zulus. The Battle of Guru, 1903, Great Britain versus Tibet, 3 British casualties, 600 Tibetans. Technologically advanced armies have an enormous advantage over less advanced enemies. This becomes much more extreme in the nuclear era and in the era of air power. So in the first Persian Gulf War, the coalition lost 200. The Iraqi army lost tens of thousands. In Kosovo, there were hundreds of the enemy's fighters that were killed, and at least several hundred civilians were killed, and the losses to NATO were 0. In the Israeli Operation Cast Lead, the Gaza campaign, there were 10 Israeli dead, some of them by friendly fire, and hundreds of Palestinian Gazan civilians who were dead. So these asymmetries are really striking, and technology only makes them more striking. So to think about our problems, what I want to suggest, I'm going to be proposing a way of thinking about them as instances of a more general problem about one set of people passing along risks to other sets of people. This is where this overlaps with the subject of tort. And I want us to consider it with a kind of schematic, basic scenario. And that is a modern army fighting against insurgents or militants who are embedded in a civilian population, let's say in a city. So something that was very common in Iraq, in Afghanistan. And we're going to suppose that the modern army has two alternatives, which I'm going to call close engagement and distant engagement. In close engagement, infantry is sent in, and they go door to door, house to house, and they have rules of engagement that say that they hold their fire unless it's absolutely necessary to shoot in self-defense, and they do that in order to minimize civilian casualties. Distant engagement means, let's say, mortar fire comes from a courtyard, call in the bombers and obliterate the house. And I'm going to suppose what is almost certainly true, that in distant engagement, the number of civilian casualties is going to be a lot higher than in close engagement. But in close engagement, the Army is at greater risk. Now, this takes us to the two questions that I began with. I haven't said anything yet about who these civilians are. Suppose that an enemy has taken one of your own cities hostage. They might be your own civilians. So one question is, regardless of identity, do soldiers have to take on avoidable personal risks in order to minimize civilian casualties? Do they have to use close engagement rather than distant engagement to minimize casualties among civilians, anybody's civilians, including their own civilians? And then the second question is, may soldiers take fewer risks to minimize enemy civilian casualties than morality requires for friendly civilians? Now, let's call the minimum amount of risk that morality requires soldiers to take to protect their own civilians from becoming collateral damage, minimally acceptable care. Okay, so this is the minimal care that you would take if you knew that the people, the civilians in this city, were your own. Then the second question is the standard of minimal care different if they're your own or the enemy's? Now, there's an important point here. I'm not arguing that soldiers aren't permitted to take on higher risks, to fight more heroically than minimum care would require them to do. And I'm also not arguing that they couldn't do this in a one-sided way, only to protect their own folks and not the enemy's. So there might be a differential standard, but that's talking about permission. And my question is, how about the requirement? Okay, now, in response to the first question, do soldiers have to take on any risk at all to spare civilians? Or can they always use distant engagement? And here, once again, think of their own civilians. The answer that I'm most attracted to comes from a form of what I'll call risk egalitarianism. And that is the view that even if morality does permit people sometimes to transfer risks to each other. Example, I buy a massive SUV because I think it's safer in collisions, and suppose I'm right. But you're driving around in a little VW Bug, and now your risk in a collision with my Toyota Leviathan goes up. So I have transferred risk from myself to you. But ordinarily, we don't think that people cannot do that. So I think that morality sometimes does allow people to transfer risk to each other, and you can reflect on what the set of cases are in which that's true and which they aren't. But transferring very large risks to other people in order to spare yourself very small risks violates a moral principle of risk egalitarianism, and that is because it, in effect, treats my life as worth a lot more than yours. Okay. Now, in response to the second question, their civilians or ours, I'm going to argue that the special obligation that soldiers owe to their own civilians is to protect them from an enemy's violence. But in the basic scenario that I've described, close engagement versus distant engagement, the issue is protecting the civilians from our own violence. And I think that protecting people from our own violence is a universal obligation, not a special obligation. So it might be that each state's armies has a special obligation to protect its own people from an enemy's violence, and it doesn't have any similar obligation to foreigners. Matters change if the army is sent in on a humanitarian mission, when maybe the foreigners get that same obligation. But we're not talking about the special obligation to protect our constituency from enemy violence. What we are talking about is protecting them from our violence, and that's what I think is the universal obligation. Now, in the paper, I developed this through a kind of semi-quantitative apparatus, which I think it's not really necessary for purposes of this talk to go into the details, but I'm trying to imagine this. Each of these two strategies, close engagement and distant engagement, we can talk about what the risk is to the soldiers and what the risk is to the civilians. So there are 4 different risk levels, 2 times 2, that don't necessarily have anything to do with each other. Think of the difference between the risk level to soldiers between the 2 strategies as the marginal risk to soldiers. The difference between the danger to civilians between the 2 strategies is the marginal risk to civilians. And now let's make a ratio. Call it the risk transfer ratio. And what that would say is, I'm transferring 2 units of risk to you in order to spare myself 1 unit of risk. So the risk transfer ratio is 2 to 1. And my risk egalitarianism is basically an argument that other things being equal, we should make the risk transfer ratios as close to as possible to a 1-to-1 ratio, because otherwise we are simply treating our lives as worth more than theirs. Okay, that's the approach that I want to take to the first question, soldier versus civilian. The soldier can't simply transfer large quantities of risk onto the civilian in order to spare himself or herself small marginal risks. That violates risk egalitarianism. Now let's move to the second question, which is it different if it's their civilians and ours? Now, one argument, I've already sketched my basic response, but let me flesh it out a bit. One argument on behalf of the kasher yadlin view, namely, our people matter more than their people from the point of view of the soldier's obligations, is that we have a special relationship to our people. You wouldn't ask somebody, for example, to take the same risks for a perfect stranger that they would take to spare their own child or their own spouse or others that they love. There's a special relationship between them, which means that egalitarianism is simply out of place. Now, here the analogy is between our fellow citizens and an extended family. They are our people. And you can't ask us to take the risks to spare their people that are the same as our people. Here's a quote from Tom Herka. "The relations among citizens of a nation are not as close as between parents and children, but common sense still calls for some partiality toward fellow citizens and certainly demands that partiality of governments." Now, to this intuition, my reply is that these special relationships are a tricky thing. That special obligation might hold with respect to certain things. As an American, I might feel a stronger obligation to rebuild hurricane-devastated New Orleans than I do hurricane-devastated Port-au-Prince. New Orleans is us. If I might feel more obligation to send in our soldiers to rescue American hostages than I would, to rescue Canadian hostages, and Canadian soldiers the same. But there are other places in which partiality of this sort is completely out of place. Suppose that a Canadian and a Frenchman are colleagues in a bank robbery. Canada's special obligation to its own does not mean that the Canadian should automatically get a shorter sentence. Okay. In litigation between a Canadian and a foreigner in a Canadian court, it would be morally wrong for Canada to impose a rule that says that the burden of proof is much higher for the foreigner than for the Canadian just because of their identity. And if we were talking about something like donating blood in a hospital, I'd think that my intuition is that anybody who says, I want my blood only to go to somebody of my own nationality, don't give my blood to the foreigners, that's not a worthwhile, morally worthy special obligation. That's just creepy jingoism or racism. What I want to suggest is that, therefore, that special obligations are not an excuse for across-the-board nepotism. That there's some places, in some institutional settings, in which impartiality and universality govern even when there are special obligations. And I want to suggest that the military context that I'm talking about is one of them. Now, one writer says, on the other side, a soldier's job is not to protect any civilian, qua-civilian, but only to protect his co-civilians. My comment is that equivocates on two senses of protect. Yes, to protect against enemy violence. No, to protect against one's own violence. The negative duty to avoid inflicting violence, you yourself inflicting violence on innocent strangers, I think is a universal duty. Otherwise, I could take less care when I'm driving my car in a foreign city than I would in my own country, because after all, I don't have as much of an obligation to protect other people from my violence if they're not my fellow nationals. Next question is, how much risk? How much risk do soldiers have to take on? And obviously, there is no quantitative answer. But I've suggested that it should be as close to the risk egalitarian answer as possible. I want to approach this through a couple. How am I doing on time? I've got about 5 minutes left. Or
maybe a little bit more.
Okay. I'd like to take two analogies there and develop them. One is analogize a soldier invading an enemy city with somebody in civilian life who is engaged in an ultra-hazardous occupation, like blasting with dynamite or shipping dangerous chemicals. Now, we know from in tort law that if you're engaged in an ultra-hazardous occupation, then the risk of paying damages falls on you. This is Rylands versus Fletcher, the old chestnut. When one person in managing his own affairs causes, however innocently, damage to another, it is obviously only just that he should be the party to suffer. This is from Oliver Wendell Holmes. In the cases put, the plaintiff has done nothing. The defendant, on the other hand, has chosen to act. As between the two, the party whose voluntary conduct has caused the damage should suffer, rather than the one who's had no share in producing it. Now, admittedly, they're talking about when they say suffer, they're talking about who does the financial burden of this accident fall on. And I'm talking about something very different. Who runs the risk of losing their own life? But I would propose, in line with those intuitions, that if I'm engaged in shipping dangerous chemicals and something goes awry and life is jeopardized, that for me to simply flee the scene and allow the innocent bystanders to suffer death is morally wrong. I exposed them to the danger, so I have to take on the extra burden of risk in order to protect them from the danger that I myself have created. So that's the first analogy that I want to press, is this asymmetric tort analogy. It's kind of like Epstein's theory of strict liability, that causation does matter, even if we're both innocent. In a moral sense, if I'm causing the situation which creates a fatal trade-off, your life or mine, then I bear the burden of taking the extra risk. The second analogy that I'd like to press is with certain professions that involve taking risks for other people. Think firefighters, think police officers, think physicians who are treating epidemics of highly contagious diseases and go into the hospital even though they themselves might be exposed, where there is a professional code of honor that requires taking on supererogatory risks. And I should mention that in the paper, I give some quotations. Right after the Israeli-Gaza campaign, I wrote to some military officers that I know who teach at the U.S. Military Academy, and asked them, what do you think about the close engagement versus distant engagement? And all of them had a very strong belief that part of the soldier's code of honor is that you take on certain risks for other people, and that includes civilians, and that includes enemy civilians. So both of those analogies suggest that back in our original scenario, that close engagement is the moral requirement rather than disengagement. Even under close engagement, the risk transfer ratio is almost certainly going to be heavily favoring the soldiers. They have the training, they have the equipment, they have the backup, they have the helicopters with traumatic medical care specialists waiting for them. Almost certainly, they're transferring far more units of risk to the civilians in that area if they engage in distant engagement than they're taking on by close engagement. Now, just to wrap this up, I'd like to consider a couple of counter-arguments. One is that, like it or not, soldiers do count more than civilians, because soldiers are not only people in their own right who, as risk egalitarians, we think have the same rights to live as anybody else, but also they are military assets for their own side, and they will oftentimes describe themselves that way. So they count more. My response is that is a form of double counting that is illegitimate. Insofar as a soldier is an asset, and soldiers sometimes do talk about themselves that way, it means that he is setting his personal interest aside. If the mission requires him to give his life, being an asset means that he gives his life. Insofar as we're regarding the soldier as a human being first, with an incalculable personal interest in survival, then we're not thinking of that soldier as an asset. This is very close to Kant's distinction between thinking of a person as a means and thinking of them as an end in themselves. And to double count the soldier and not double count the civilian is simply illegitimate. I mean, after all, that civilian is an asset too, or maybe. That civilian might be a surgeon who is going to save thousands of lives over the course of her life, or a mother of 8 whose traumatic brain injury is going to be devastating to her family, or the person who negotiates the child who negotiates to bring a lasting peace. You know, you can't simply count soldiers as assets in a kind of utilitarian calculus without counting the civilians as assets. And if you are treating them as ends in themselves, then you can't, then the asset argument makes no sense. The final argument I'd like to look at is this. It's a version of soldiers as assets, and this is a real political worry. Sometimes minimizing our side's casualties is a precondition for being able to fight at all. This was, for example, Bill Clinton's dilemma in Kosovo. It was clear that the American public was extraordinarily risk-averse, casualty-averse. And if Clinton had said, there'll be boots on the ground, I think the same things happened this past spring in Libya. There would have been no political support for the war at all. But just sending in planes is distant engagement, and it probably jeopardized and cost more civilian lives. At least there's some significant evidence of that. And in fact, the ICTY prosecutor appointed a panel to see whether NATO had committed war crimes, in which that disproportion was one of the things that they talked about. What if the public's extremely casualty averse? Well, in that case, it might be a military necessity for you to keep casualties down. And in that case, force protection becomes something that is not simply a nice thing, but a military necessity. That's the argument. And here's my response to the argument, and that's what I'll close with. It carries a completely unacceptable implication. The implication's this: the more casualty averse our public is, the more unintended collateral casualties under this argument we would be allowed to inflict on the enemy civilians to keep up our own morale, or our public's morale, or political support for the war. That would create an incredible moral hazard and perverse incentive. It practically invites a public to become more casualty averse, but it simply can't be the case that the less will a country has to fight, the less obligation it has to fight well, because that would spell the complete end to the law of morality, or the law and morality of war. So let me stop there.
Thank you very much, Professor Lubin. We have a response by Danny.
Thank you. Let me begin by saying that I found David Lubin's paper very, very thought-provoking. And I don't just mean that in the boilerplate way in which every paper to which one responds is necessarily thought-provoking. I admit to not having thought much about these issues, not carefully, and that David's paper forced me to do so. And I admit that even now, I'm not sure to what extent I agree or disagree with him. I'm very conflicted about these questions. Some of what he said seemed to me powerful and convincing, very interesting, but about other aspects I was less certain. I found the one bit that actually did not talk much about the risk transfer ratios, very interesting and illuminating way of thinking about these issues. So what I offer here are more thoughts rather than a direct argument, and they are meant to offer directions for further discussion here rather than a direct rebuttal or disagreement. So let's start. So I admit that when I studied the law of war back when I had a course in public international law some years ago now, I always found them somewhat odd. So it's rules that kind of say you're allowed to kill in this way but not that way. You're allowed to kill conventionally but not non-conventionally. And though I did not think about this in that way then, I must say that these rules make more sense not as part of morality but rather as a sort of result of strategic planning intending to contain the harm of war. And if that makes me what international relations scholars call a realist, then so be it. Game theory rather than moral philosophy seems a better tool for understanding at least how these rules emerged. And even in Margalit and Walzer's purportedly moral argument, they stress the importance of limiting the destruction caused by war and incidentally keeping it away from those in power for reasons that cannot be justified completely, I think, on moral grounds. So they speak there about the significance of containing the war. And that sounds like something that a kind of game theoretical argument that I'm sure exists, even though I've not read it, about the laws of war could explain well. After all, it is undeniable, and no one denies this, David definitely did not deny, that soldiers are citizens, and before that, they are human beings. And it is hard to see what is it about being a soldier that could alter one's moral right to live. I say all this perhaps because I am, I think, more skeptical than David about the possibility of moral philosophy to provide us with answers to the sorts of conundrums that he raises. And to show why, I would like to consider some recent work in moral psychology. Recent years have seen some new and interesting research on the psychology of morality, and what has been called the emerging consensus is that morality has 5 foundations: harm, fairness, purity, hierarchy, and the one important for us here, in-group, out-group distinction. For those interested in a short introduction to this, Jonathan Haidt, who is a psychologist working on morality and has done some very interesting work, has a short article in Science of 2007, in which these considerations are laid out. The fact that for many people the in-group, out-group distinction is a fundamental moral distinction is not to be ignored lightly, or it's not to be taken lightly. David does not ignore it, of course, but he considers it, I think, rather narrowly. So he tells us that we are entitled to treat those close to us differently than others, but he says that, but he's more skeptical or more demanding that we limit the in-group, out-group distinction. Rather, we take it rather narrowly when we're looking outside the family. So remember his examples in the talk about the way courts should behave, blood donations, and so on. I suspect that this is not a view that he shares with many others. I suspect many others would take the in-group, out-group distinction would consider it more important. And interestingly, when the matter was studied empirically, it was indeed found that people who identified themselves as liberals tended to give much lower weight or much lower significance to the in-group, out-group considerations than to considerations of harm and fairness. That, incidentally, is another paper, but by Haidt. In other words, for many people, the preference for members of their own group is not just a gut feeling that can be subjected to critical analysis and then considered mistaken, but rather the bedrock that moral arguments has to explain. Okay? It's the kind of starting point that we cannot do, the non-negotiable starting point. And I should add that even though I suppose many people would accept that there are contexts in which the in-group, out-group distinction is one that should not be taken into account. I think the court example that David provided is definitely one. War is exactly the kind of situation in which the in-group, out-group distinction is taken precedence, and especially with regard to the enemy. So that's kind of a starting point, and you may say, yes, but this is all interesting stuff about moral psychology. What about the morality? And so I'm turning now more to this. And I want to consider one issue that David addresses in his paper, but not directly, and that is who are the rules that he favors or that directed at. And roughly speaking, I see 3 possible targets for these rules. The first is the individual soldier, or low-level commanders, the lieutenants and captains, those who are in the field. The second level is the senior commanders, probably not lower actually than generals. And finally, the third level is the political leadership. And much of David's discussion focuses on 1 and 3, that is the individual level and the political leadership that we're talking about. But for 2 main reasons, I think actually it's number two, the senior commanders, who are going to be the ones who, to whom this question should be directed at. And let me explain why. First, the scenario that he depicts, the basic scenario, the close encounter versus the distant encounter, involves a strategic decision. This is the sort of decision that is not in the hands even of army majors, probably not even army colonels. It's the sort of decision that is taken at the very least by army generals. You might say that there may well be variations on the basic scenario in which the decision will be at the hands of commanding officers or even individual soldiers. Think of the example of Frank Richards. But I suspect these cases are more likely to be, especially in the theater of modern warfare, less common. That it's most of the time the kind of question that we're dealing with is a question that's raised at the higher level of generals. The second and more important reason why it matters who the question is directed at is that if we actually consider the soldiers in battlefield, I think it's very difficult to expect them to behave differently. And there are several reasons for this. The first is that war puts people under incredible pressure. This pressure involves the sort of considerations that David has talked about: lack of sleep, lack of food, knowledge of friends, or familiarity of friends who have died. But I think the most basic source of pressure is simply fear, and the most literally primeval fear that we have, the fear of dying. And this fear is so powerful that soldiers who are found in it are likely to act or react in exactly the same way that people who are acting in self-defense react, that is, acting instinctively. To try to consider and carefully calibrated rules about the degrees of risk one is allowed to impose on others is simply not the sort of stuff that goes through one's head when one behaves instinctively. Secondly, armies are hierarchical institutions. In an environment of hierarchy, people tend to look for those below them to transfer to them some of the pressure they are put under. And thirdly, war requires individuals to kill others. And in order to do so, one is required to start thinking of the enemy in as somewhat less than human. I know it sounds harsh, but I think otherwise most people who have been socialized from birth to think that killing others is wrong will find the task simply too difficult. And a very vivid, I think, example of the process in which an army creates this sort of attitude in soldiers is the movie Full Metal Jacket, if you've seen it, in which the whole first part of the movie is, as I see it, is dedicated to showing how the army turns soldiers into people who treat the enemy as somewhat less than fully human. Maybe it's, now, it follows necessarily that soldiers will think of people on the other side, soldiers or civilians, as somewhat less worthy than those on this side. For all those reasons, I think it's going to be difficult to direct the question at the individual soldiers. The other possibility that David considers is politicians. And he acknowledges that politicians are under intense pressure to have casualty-free war. When by casualties, I mean, of course, our casualties. And I would add that they may even be under political pressure to beat the enemy. And beating the enemy may require not only reducing army casualties, but perhaps, in some context, increasing them. Just recall the reactions in the United States after the death of Osama bin Laden. This is perhaps an extreme case, but I can tell you that from my personal history, that in times of conflict, people tend not to be very sad about deaths of people on the other side. Sometimes they feel actually quite happy about them. For various reasons described. Now, I don't say that these are necessarily relevant political, the latter is not a relevant political considerations. But David responds that such political considerations cannot be taken into account in deciding on a course of action, in deciding on something like the basic scenario. To make, I quote from him, to make the law or morality of war hostage to political will, he says, would mean the end of the law and morality of war. I don't want to press on this matter too hard, but I want to make two comments about this. One, these sorts of considerations are always going to be taken into account, and to suggest otherwise would mean that these discussions that we're having here will continue to be academic in the bad sense of the word. But more importantly, there is, especially in the context of war, but more importantly, in a democracy, politicians are elected to save their citizens, and their primary obligation is to protect their lives. Thus, when David writes that no association obligation prevents soldiers from taking the same standard of care for enemy civilians as they do to home civilians, he underplays the fact that soldiers are owed certain, I think he underplays the fact that soldiers are owed certain obligations by other members of their society, including especially their government. And I want to add another thing. The home casualties of war are not only the dead soldiers. It is their families and friends, their workplaces and clubs. And for a state leader who does not reduce death of her citizens to a minimum, injures the interests of these non-soldiers as well. And these may be relevant political considerations for a political leader to take. We're left, therefore, with the level of army generals, and it is only they who have the capacity and power to decide whether to launch CE, that is close encounter, or DE, distant encounter. And unlike politicians, they do not face the sort of political pressures that politicians face. So they may seem like the right candidates for these sorts of arguments. But here's the difficulty that I see with them here. It is easy to describe, and I would stress or suggest correctly describe, minimum casualties as part of the military goals of any military operation. Any given operation is judged, among other things, by the number of our casualties. And other things being equal, a military operation with more casualties is a worse military operation in this regard. Indeed, with enough casualties, the operation might be considered a failure. Think of Pyrrhus and his victory. The basic scenario asks us to consider a certain military goal that may be achieved in the same way. One distant encounter and one close encounter. But consider the following example. An army general faces two possible battle plans. One is judged from the military perspective to be better. It is more likely to lead the other side to surrender, for example. It will place home soldiers in more controlling position, whatever. But this possibility is also expected to lead to a higher number of enemy civilian casualties. Can the general adopt the one that is more likely to promote our goals at the sake of higher number of casualties for the enemy? If you answered yes, then the problem that we face is that you can always add fewer casualties to the considerations that an army general will take. I hope this example was clear. Okay, so if we take fewer casualties as one advantage, and if you think that other things being equal, an attack that promotes the military goals of the army better than another is permissible, but maybe I'm wrong about this, even if it involves a higher number of casualties for the other side. Well, I have a few more things to say, but my time is up, so maybe I'll stop now, and if there's a chance, I'll just raise my hand afterwards. And
makes sense.
Okay.
We leave time for discussion, and so
Yeah,
if it
so-
comes up, or just raise
So let me just conclude by saying I hope these kind of more realist considerations are not considered irrelevant. But I think that when developing an answer to these very difficult problems, we have to take them into account. I'll just finish it with one more positive note. I think all this suggests the difficulty, and perhaps this is a different discussion, all this suggests that we should, because of the difficulty of controlling or dealing with questions of morality during war, all this suggests that the morality with regard to entering into war should be toughened up. It should be the sort of cheerleading towards war that we see is something that those of us who are concerned about human lives of ours and to the lives of civilian enemies is the sort of thing that we should always remember. And war is always worse than people think it is. And therefore, it is at that stage, at the stage of getting into war, that we should focus our attention. Okay.
Well, thank you to both our speakers. I think maybe if you want to take 5 minutes to respond to some of these thoughts, if you have anything that you want to discuss.
Well, I think that this tees up all of the important issues, or many of the important issues. So I'll say something, some things that are very brief. First, who am I directing this to? I'm not directing it to the soldier in the field for the reasons that you said. Not so much to the politician either. What I'm directing it to is, I'm not sure if it's a senior commander or a mid-level commander or a lawyer who is writing the rules of engagement. So if I'm thinking in terms of the current United States military plan in Afghanistan, it's based on the counterinsurgency COIN doctrine, which is close engagement, and trying to minimize civilian casualties for strategic reasons. It's a hearts and minds strategy. Apparently has many soldiers really angry. Why do we have to not shoot? This isn't, this is jeopardizing us. But it's whoever is writing the rules of engagement that are given to the soldier. And I think that that's because it's just too much to ask somebody who's going into the heat of combat to say, treat yourself and this other person as though you are you're both equally valuable. I might say, yeah, in God's eyes, I know we're both equally valuable, but we also have self-preference, and I don't have to. That doesn't mean that I can't look out for number one. So you ask somebody else to write the rules. Now, with respect to your last point, isn't force protection one of the goals of a military strategy? Sure it is, but it can't be, I think I mentioned this in the paper, it can't be given absolute weight, because if it's absolute weight as a military goal, then you could simply drop a hydrogen bomb on the enemy and say, gee, we managed to wipe out every last person living in that city, but that's collateral damage. And since force protection has absolute weight, it's not disproportionate collateral damage. So somehow you're involved in a line drawing. And I don't think there are bright line distinctions. I mean, the laws of war say that armies have to take all the steps that are feasible to minimize civilian casualties, but the law never says what feasible is. I mean, feasible can't mean if it's technologically possible, but suicidal, you still have to do it. But it also can't mean that if it raises your risk even by 1/1000th, then you don't have to do it. It's got to be somewhere in between. The kind of dilemma is something that I think is very real for. Now I'm not talking about rules of engagement people, but soldiers. Many U.S. troops in Iraq, including, I must say, one of my own students who came back to law school afterwards, talked about the terrible dilemma of working at a checkpoint and seeing a civilian walking toward you holding a cell phone. Is this person a civilian walking toward you holding a cell phone, or is it a spotter for mortar fire who's going to say, now? What do? Do you hold fire or not? You shout warnings, and the person doesn't respond, but maybe they don't hear them, or maybe they don't know your language, or you don't know their language. So it's a very, it's a line drawing exercise. Now, the moral psychology point, I think that this is something that we should we should talk about in the general discussion. To me, the fact, I do acknowledge that polarization between in-groups and out-groups is a psychological reality. But I don't think that morality can just stop by accepting every psychological reality, because I mean, morality is in many ways an attempt for us to overcome the worse angels of our nature with reason, or with the better angels of our nature. I'd also like to point out that in-group, out-group polarization is something that is highly manipulable. So, I mean, there was one classic set of experiments in which children were asked to be on opposite sides in a tug of war at a day camp, and then afterwards asked to discuss each other as human beings, and it was always the people on the other side were just inferior as human beings to our side. Children who were told that that psychological tests have shown that they prefer, I mean, this is teenagers, Kandinsky to Clay, ended up thinking that other people who prefer, it was completely false, by the way, no tests had shown that, that people who like Kandinsky are just better people than people who like Clay. I mean, it's very easy to polarize people, and one of the jobs of the law of war is to, and I think the morality of war, is to take people who are in a situation that's really unusual for a civilian, something in which lots of things are really counterintuitive. For example, not fleeing when there's really bad stuff happening on all sides, disciplining them to do that which runs contrary to their psychology. And one way to think about the law and morality of war is that it's trying to change the polarization so that the in-group becomes us and non-combatants. The out-group is enemy fighters. And to try to train us to respond to that as the polarization, rather than, you know, they're all people of this other nationality. It's hard, but I don't think that we should just give up the moral task. And finally, I think it's a very interesting question whether the rules of war are just beyond morality. I think there are strong arguments for saying that, you know, in war, ordinary rules of morality couldn't possibly apply, because ordinary rules of morality tie a person's liability to being killed to them doing something wrong, and wars don't work that way. So that maybe all that the rules of war are trying to do is to take a situation that is conceitedly beyond morality and just do a little bit of mitigation in it. That doesn't feel right to me, because it seems to me that the distinctions that we're talking about when we talk about the rules of warfare, the moral rules or the legal rules, aren't just pure conventions. I mean, they're conventions plus. They're conventions that seem to have some moral basis behind them. So, for example, the convention that says you can target an enemy in uniform, you can't target a civilian, that doesn't track moral liability. The person wearing the uniform could be the cook, or they could be asleep. The civilian could be the evil civilian politician who is drumming up the war, and the moral distinction between them isn't there. So we make a conventional distinction, but it's a convention plus, because it's meant to largely coincide with the distinction that matters, those who are menacing and those who aren't. And I want to be working in the region of the convention plus. So that's it.
Thank you very much, David. We'll now take questions. So I have a first question from Professor Berger. Before you ask a question, make sure you have a microphone in your hand. There are two on each side, so please circulate them. You can also detach them from their base if it's easier.
David, thank you. I really enjoyed that, and Dan, the engagement with it as well. I wanted to ask you, David, if if you bring it back to kind of where you started with the general frame of just war theory.
Yeah.
And specifically, I was wondering the extent to which, so it's kind of the boundaries that you're drawing. One of the virtues of this paper is the way it brings us into the particular conundrum that one faces in making the decisions about the manner of engagement. What was unclear to me a little bit is whether or not the cause or the nature of the cause interacts with the minimally acceptable standard in some fashion. So when we're thinking about the minimally acceptable standard or the moral calculus, the ratio that you have in mind as between the risk transfer, how much do we have to turn back to think about the overall justness of the cause writ large, right? So the interaction of that broader justness of the cause or nature of the cause and the ratio. Because my intuition is that certain kinds of causes will permit a different kind of transference of risk than other sorts of causes. And in fact, you almost allude to it when you say if we're in a civilian protection mission, then our ratio has shifted because of our objectives in some fashion. But I just wondered if you could put it back into the broader frame of just cause.
Yeah. Those of you who are conversant with contemporary debates in just war theory will know that this is an extremely contentious issue over the last 10 years. The standard, I'd say it's fair to say the standard view, it's the one that Walzer defends, it's the one that's embedded in the laws of war, and it goes back to the Middle Ages, well, to the early modern period, is that they don't have anything to do with each other, that the jus ad bellum, the justice of the war, is completely disconnected from the jus in bello, justice in war fighting, so that the Nazi soldier who fights cleanly hasn't done anything wrong in a way that, in the same way that the Allied soldier who fights cleanly hasn't done anything wrong, and that it would be a horrible travesty to say to the Nazi soldier, since you were on the unjust side, we're going to count everybody that you killed as a case of murder and give you triple life without parole. So that's the standard view. Within the last 10 years, a number of philosophers, notably Jeff McMahon at Rutgers University, have said that's got to be wrong. And Jeff uses an analogy. Suppose a burglar is coming through my window, and I, being an American, I always have a gun, right? I grab the gun from under my pillow, and I get ready to shoot the burglar, and the burglar shoots me first to save his own life. In law, and Jeff says in morality, we don't grant the burglar the privilege of self-defense in that situation because he was the aggressor. In the same way, if in World War II, the Germans cross the border into Poland, and the Polish army grabs their guns, even if they are threatening the German soldiers don't have a moral right of self-defense because they're like the burglars who have broken in. And so his view is that any killing that's done by anyone on the unjust side is morally wrong. And his conclusion is that if you're a soldier, you have to think very carefully about whether to obey an order. You have to think about whether your cause is just. Now, the problem with that, this is not just my insight, but I think many people who've responded against that, is that's too much to ask, because in general, situations don't come with non-controversial labels: just cause, just warrior, unjust warrior. Who had the just cause in, let's say, the Afghan War? The U.S. invading forces said, not implausibly, we are acting in self-defense. We've just suffered 9/11, and all of the enemy forces are being harbored by the Afghan government, and in fact have hijacked the Afghan government, so we get to defend ourselves. I think that Taliban fighters could justly say, these Americans are invaders. They are aggressing against us, and we get to defend ourselves. And if you can't get any settlement of the controversy, then it seems too much to try to make the rules of warfare hinge on which side is the just side. So think that that just war is just inevitably going to be controversial. Now, if that's the case, then we would want more symmetrical rules of war, where the just side and the unjust side fight by more or less the same rules. And that's the way in which the actual jus in bello laws are written. They apply to all sides in an armed conflict, not regardless of who was the aggressor and who wasn't. And in particular, the one that I'm talking about, it's the rule that says that you have to take every feasible step to avoid excessive civilian casualties, to minimize civilian casualties. If I could recast your question, it's does feasible grant you more latitude if you're the just warrior than the unjust warrior? I would say no. Feasible for one means feasible for the other. And that's not because the missions are equally important. It's because in both cases what we're talking about is, by stipulation, helpless, innocent civilians and keeping their losses down in a war that we have to hypothesize they're not contributing to.
Right. I have myself quick intervention.
Okay.
In defense of Jeff, he distinguishes very clearly between the rules of war, the law, and the morality. The way you respond make me wonder, what is the nature of your project? Are you more I mean, the appendix at the end of the paper is about the laws of war. It seems to us you want to talk about morality, and morality is a messy affair. Of course, Jeff in Just and Unjust War takes the paradigm of the just side and the unjust side. But in conversation and even in print now, he's acknowledged that the unit that we should be looking at is mission. And the minute we start looking at mission, things become very messy, because you have unjust and unjust that coalesce in all sorts of ways. But if we're really serious about thinking about elements that matter, I tend to be sympathetic to Ben's comment. If I'm a civilian on the unjust side, and I have contributed by my participation to this unjust action, or just to the existence of the state that led to that unjust threat being posed, could be a matter of causation, could be a matter of active participation, could be a matter of failing to participate, then it seems to me that it might be sometimes more permissible to harm me as a side effect. We're not talking about intentional harming here. There are other people who make other kinds of arguments here, who say, war on the part of the unjust state, let's just use that as the unit, can benefit these citizens, right? Some people go even further. They say having a state typically benefits citizens because the state is better at making certain kinds of decisions, such as knowing when to go to war and when it's just and unjust, such that when the state messes up, well, the citizens who typically defer to the state on these conditions, in these situations, should participate in the cost, as it were, and paying the cost. So it seems to me that this is an interesting distinction that, at least even if you reject it, ought to figure somewhere in the paper, because in a sense, and if I'm a soldier is confronted with on the just side, confronting the unjust side with citizens that, for some reason or the other, are more permissible to be harmed as side effects, then the kind of risk that I might be allowed to take might vary. And so here's again, the same intuition that comes back to the surface.
Yeah. I'm actually quite unsympathetic to that line of argument, because I think that if we are talking about the law and morality of war, we ought to assume that there's a war going on. Something that Walzer said in response to Jeff is that he's written a beautiful ethics of war if war were a peacetime activity. It isn't. So trying to line up vulnerability to attack with moral liability, it can't be done in a situation where the instruments of violence are administered at a distance and more or less collectively. So we could imagine a science fiction world. In the science fiction world, when a war starts, all the people in both societies start to glow different colors, and the color that they glow matches up with their moral culpability. so that, and then you could say you're entitled to target the blues because those are the most morally culpable. The oranges are less morally culpable, so you can shoot to wound but not to kill. To me, too much of Jeff's view is that. We're trying to match up individual liability with instruments of violence used at a distance that simply can't apply individually. So I don't think that can be what the morality of war is. Now, my own project, I mean, he wants to distinguish between the deep morality of war and the law of war, and he says asymmetrical rules of deep morality, symmetrical rules of law. I am more interested in the place in which the law and the rules of morality are more or less, are more tightly connected than that. So it's not that I think that if you look through the additional protocol of the Geneva Conventions, that the rules of war as they're laid out, could there be alternatives? Are these the best possible rules? No, but they all, it seems to me, more or less coincide with the kind of moral principle that, so the legal rules that say you have to distinguish between combatants and non-combatants are different ways of giving concrete embodiment to a moral principle that says that distinction matters. And it seems to me that those kinds of broad distinctions are the only ones that make sense if it's really war that we're talking about, in which people don't glow with different colors depending on how culpable they are.
Professor Scarano.
So I was just trying to, this is, what really, where I want to focus my comments are on the Clinton example that you gave at the end. And I'm curious about the structure of the kind of reasoning that we have within the proportionality constraint, the kinds of considerations that we can throw into, our deliberation about proportionality constraint. It seems like there's a consequentialist. Oh, sorry about that. There's a consequentialist. I don't know, cabin, as it were, where you can reason in consequentialist fashion within the doctrine of double effect here. And he had talked about one reason not to alter the rules of engagement in a way that places a higher premium on the soldiers' lives in cases of humanitarian intervention, is that it would lead to publics that are less tolerant, I take it, and more protective of force protection, that sort of consideration. But it seems like, on the other hand, it seems like if you're going to throw that sort of thing into the mix to think about what sorts of rules of engagement would be appropriate in this context, you need to throw into the mix the kind of risks that the civilians who aren't immediately, of concern in a particular engagement, but the civilians that are say in Kosovo more broadly, you have to worry about the kinds of risks that they face. The basic idea being that these kinds of humanitarian interventions might not happen at all, and maybe become more likely to happen, less likely to happen if the rules of engagement have to be as protective as you suggest. And so I guess my basic question is, I'd like to hear more about the worries or the kind of risks that civilians who aren't at risk in the particular theater of the moment, what kind of role their risks might play in the reasonings about the particular rules of engagement in a particular case.
Yeah, no, I mean, I think it's really important and good question. And by the way, I would invite anybody else to jump in on any of these questions when you have something to say. I mean, I'd rather do this as seminar style than just constant questions and answers. I mean, look, this was Clinton's dilemma. I would like to do a humanitarian intervention. Let's just suppose for a moment that his motives were pure. I mean, it's a big supposition for any political leader. I'd like to do a humanitarian intervention, but the American public won't tolerate any casualties for a humanitarian intervention. So I really, if I want to do something on behalf of the Kosovars at all, then it has to be something that creates more civilian casualties than, let's give two examples, boots on the ground would, a ground force, or the particular choice that was made, which was how high the bombers were flying. If they fly low, they can do something that's more discriminating. There's some factual controversy about that, but let's assume that that's true. But they're taking on higher risk for themselves, and the NATO decided to fly their bombers quite high so that they couldn't actually see as well whether the targets that they were dropping bombs on really were the enemy or just civilian caravans. In both of those cases, the political calculus is clear. We don't want to take casualties because our folks won't accept casualties, and better than nothing. That's, I mean, I take your point that if you ask the Kosovar who's not getting hit by a bomb, do you want this intervention or don't you? That there's a utilitarian way of saying, let's just see, given these two possibilities, high casualties for civilians, none for NATO, or nothing at all, no intervention.
And hundreds of dead, hundreds, maybe thousands.
That's a tragic choice, but it's not one that I would want to model the morality of force protection on, because for the reason that I said in a kind of compressed way, that then it gives the civilians back home a perverse incentive to be more casualty averse. Okay, right? So it's like, well, we're not going to do any humanitarian intervention. There's a difference between, we're not going to do a humanitarian intervention if it costs thousands of lives. You'd better keep it down to hundreds, versus what you had around Kosovo, which is there better not be any at all, or just a tiny handful, in which case the political shyness, gun shyness of the population ends up jacking up the number of unnecessary civilian casualties enormously. It seems to me that that's too perverse to permit as a rule of morality.
So can I just follow up just briefly?
Yeah.
And I can keep this short. You teed it up nicely. But at that point, I guess it's the structure of the reasoning. I mean, is this a consequentialist argument? That, I mean, could there be a case of, so you're worried about the perverse incentives and the kind of loss of life that might ultimately lead to in future rules of engagement, but shouldn't that just be balanced against the possible loss of life that might occur if you don't engage in any humanitarian intervention at this point? Or, well, I'll just stop there.
Yeah. I think that practical morality always has to take consequences into account, but I am not a consequentialist in general, because I think that consequences are really hard to predict and that we're mostly just fooling ourselves when we think we can do the calculations. And I think warfare raised that to the 25th power. Warfare initiates processes in which the end point is incalculable. So, I think that you take your best guess, and you're not indifferent to consequences, but basically you don't craft the rules, moral rules or legal rules, around the outcome of a consequentialist calculation like that.
Can you pass the microphone to the person next to you?
Sorry, you talked about Professor Thomas Harka from U of T, University
Yes.
of Toronto. What was your point about that? It was 2 years ago, I think I was in his presentation, and then in my foolish youth, then I found it very natural.
Well, I was just borrowing one sentence from him, so I wasn't talking about an argument as a whole. Let me read the sentence again. The relations among citizens of a nation are not as close as between parents and children, but common sense still calls for some partiality toward fellow citizens and certainly demands that partiality of governments. So my point was common sense is a slippery creature. It demands partiality on some things, but not across the board nepotism. Okay.
Professor Scott.
Professor Lubin, I just want to go back to your the anecdote about having contacted your friends at the National Defense College, or
Yeah, it was the U.S. Military
U.S.
Academy.
Military College, and them giving an answer that I've heard too from Canadian military folks along the lines of there are certain things as a soldier you have to accept as part of your role, and if that means taking extra risks to protect civilians, then that's what we should do. That was more or less what they
Right.
responded, right? So what I'm wondering is, in your framework, where do you see virtue in the sense of old-fashioned virtue ethics coming in? If we think about the laws of war, there's a good number of the rules that can be kind of rethought as basically about reciprocity and things, but a lot of them still had their sort of origins and even notions of chivalry and honor to some extent. And the comment from the folks you were talking to, there seems to be a huge honor quotient there that isn't only about a kind of an abstract analysis of what we owe each other contextualized to the context of war, but it's something about who I am as a professional military soldier. And so I'm kind of wondering if you think that either does or should play a role in assisting, or maybe it counters, but I think it probably assists your arguments, whether or not the idea of honorable conduct as a point of character or point of virtue that's focused on the actor and not so much on the reciprocity in the relationship, whether that has a role to play in how you think about these things, or is it a framework that you don't generally embrace and therefore its relevance is limited?
Yeah, it plays an extremely important role, and it's virtue. I mean, when I talked about the soldier's code of honor, that's completely a virtue ethical framework. It wasn't the only piece, the only pillar of the argument. I was using two analogies. One is to think of the soldiers as something like people engaged in ultra-hazardous activity, and that's not a virtue ethical analogy. The other is to think of them as like people who are taking on a profession that has risk written into its DNA, like firefighters and police, and that does have everything to do with virtue and honor. I'm a little cautious about how far to push it, because I'm very conscious that the people that I was talking with were, first of all, educated officers, volunteers, military, so to speak, lifers. They're spending their whole career within the military, and not coincidentally ethics professors at a military academy. That's obviously not the same as somebody who is drafted into the Army, or somebody who has joined the Army out of economic necessity and who maybe just wants to come home with his or her skin intact. So, I would never feel like I could walk into a room filled with soldiers and say, all of you are honor bound to take the utmost of risk for enemy civilians, and think that I was talking something that spoke to them. But I think it's certainly the case that within the officer corps, that those virtue ethical constructs of honor are going to matter a lot more than impartialist moral arguments, and they probably should matter a lot more. Let me just say one other thing, which is you mentioned that the law of war comes out of chivalric traditions, and to me, I think that one of the interesting things for legal theorists to think about is that there are really three different sources for the laws of war. And I think right now all of the debates are about how we put those three things together. One of them is chivalry. So, for example, there is a current law of war, rule of war, that says that you cannot kill an enemy pervidiously. Okay, so that's a chivalric concept. Perfidy means you're pretending to be dead, and then you jump up and kill them, or you abuse the white flag or something like that. The second big stream is humanitarianism, which is surely the desire to reduce suffering. War is a horrible business. Can we mitigate its horrors and reduce suffering? Think of that as the Benthamite strand of trying to reduce pain. And the third, which is much more modern, is human rights. This is more Kant than Bentham. It's more individual human dignity than maximizing net suffering or living up to the chivalric code of honor, and those things don't always map onto each other neatly. The biggest problem is that war is an inherently collectivizing activity, and it's really hard to see where individual human rights and human dignity get any kind of purchase against this brute collectivization. And I think that if you read the law journals about how do you fit humanitarian law and human rights law together, which turns out to be a set of quite technical legal issues, scrape away the technicality, and you find the fact that we just don't know how to think about warfare. We don't know whether to think about it as something that should be governed by civilian concepts of human rights and human dignity, or by a humanitarian, let's see what we can do to minimize the pain, not just to the wounded soldiers and civilians, but to the wounded dogs and cats and horses as well. It's pain is pain. Or how can we have virtuous knights? Those are really very different.
What does a Kantian scholar have to say about this, Professor Hartson? I don't mean to put you on the spot.
So I found your thesis very, very plausible in the case of, as you put it, innocent enemy civilians. I was wondering if there's anything
Microphone.
Just
Just
I was wondering if there's anything that civilians can do that would make them less innocent, short of taking part in the war efforts. Well, obviously, if they work in a munition plant or something like that, then that would be a special case. But if we consider them just as civilians, so you said if they express joy at deaths on the other side, that doesn't justify a death sentence, and that's certainly true. But as François pointed out, we're talking about unintentional killing. So I'm wondering, is there a level of support for the belligerent government that would make civilians less innocent? Is there a level of control if they voted them in? If there was a referendum on the war, I know this doesn't really ever happen, but suppose there's a case where there was a referendum, 95% of the people voted for the war. Does that make a difference to how much protection they're entitled to from our forces?
Yeah. Two possible ways of thinking about this. One more a kind of rule-based, and the second individual liability-based. The rule-based would say, let's see if we can come up with the best war convention, which I think doesn't make those kinds of distinctions, and then apply it in cases. The challenge is, suppose that there are cases in which we really can say, these people are themselves quite culpable of the war effort, that it's their financial support, their cheerleading, their unceasing belligerency that makes the war effort possible. To me, the problem is that might suggest that they need some kind of punishment. And I've actually written a paper about whether, as a category of international criminal law, states, rather than just natural persons, should be targets of punishment, and I say yes. But I don't think that war itself is the instrument of punishment, because war doesn't discriminate. I mean, in fact, you can't target the guilty mother without the four non-guilty children that are living in the same bedroom as the guilty mother. And in general, I think that the collective, the remorseless collectivization of the instruments of violence that we use just make the idea of trying to sort people by individual culpability too fanciful. And if we could say, look, here's an entire society that is all just gung-ho on the war effort, maybe their civilians lose some protection, I'd say that's science fiction. Okay. Now, the way that this debate is playing out right now among the lawyers and theorists is with a question about who counts as a direct participant in hostilities. The Red Cross has issued a report about this, and there are a couple of judicial decisions. Under current laws of war, a civilian who directly participates in hostilities loses his or her immunity. And then the question is, what's a direct participant? Let's take a militant tactic, suicide bombing. The suicide bomber, clearly a direct participant. The person who is strapping the suicide vest onto the bomber, clearly a direct participant. The person who makes the explosives is a direct participant. The way that the Red Cross conceptualizes it is that anybody who is one causal step removed from the violence is a direct participant, and that might include all of those. But if they're more than one causal step removed, then their participation is much less direct. So I think that region of the War Convention is more or less the right answer, which is to draw direct participation, the circle of direct participation who lose their immunity, just much more tightly and not more loosely.
Professor Myers.
Yes, I didn't get a chance to read the paper beforehand, so this may be addressed. I'm just wondering how the risk egalitarianism would work in certain more extreme and maybe more fanciful sorts of cases, but maybe not more fanciful, I don't know. But I mean, suppose we're very good at the distance engagement, so the risk to our forces there is effectively nothing. But suppose we're not very good at the close engagement, so we go that way and the risk becomes very, very high. And perhaps the risk to the civilians quite low. If there's no nice continuum, what do we do? How does it go?
That's a good question. I actually did qualify the argument of my paper with that in mind in a part that I didn't talk about. So it seems to me that the risk egalitarianism is just talking about the ratio of risk to risk, but the absolute magnitude matters as well. That when the risk to the soldier becomes too high, then maybe this is the concession to the moral psychology, then it's just too much to ask that I take on that level of risk. So what's crucial in my diagnosis of the particular situation is that generally with professionalized armies, the risks of going into these civilian neighborhoods aren't very high. That we're not talking about 50% chance of death. We're talking about 1% chance or 1/10 of 1% chance, and then the choice between that and distant engagement is basically a marginal risk to yourself of 1/1000th. And it's for the reasons that I mentioned, that soldiers are trained, they're armored, they're armed, their adversaries, and certainly the civilians around aren't trained, armored, and armed. I mean, they may be armed, but they don't know how to use the arms. Their arms aren't as effective. The soldiers have been inculcated in an ethic of looking out for each other, which the unorganized adversary generally hasn't been. The medical backup for the state's army is usually orders of magnitude better than whatever medical assistance the insurgents have, and certainly the civilians. So generally when the soldiers are coming in, their risks aren't in what I would think of as the red zone, where you just can't ask somebody to take that kind of risk. I mean, you can ask a firefighter to go into some burning buildings, but you don't ask firefighters to go into a burning building where the chance of coming out is only 1 out of 4. Yeah.
Professor Priel.
Thanks. Well, the discussion here raised so many issues, so I'll try to ask just 2 that kind of raised from your discussion. So, you gave the examples of huge disparity in casualties, and at least as I understand, in many of those cases, all casualties on both sides are actually combatants.
That's right.
So, does your argument have any application, or I'd be interested to know what are your views about that? So is an army in some way limited in the way that it advances its military cause if it means that there are going to be huge losses to the other side's combatant that are in great disparity between to the casualties? So let's say that you can have distant encounter and close encounter in which all the casualties will be combatants. Is it permissible then, on your view, for the army to engage in distant encounter when?
Well, I tend to think about this more or less along the lines of traditional just war theory, which begins with something that in one sense is obvious but feels morally perverse. When you're attacking enemy fighters, more dead people is better than fewer dead people. Your object isn't to spare enemy fighters. Your object is to degrade the enemy forces to the point of forcing surrender. Does that mean that inflicting gratuitous harm is okay? Well, that's the limit, is that you can't go beyond what is necessary in order to compel victory. So,
but what about for the sake of force protection?
There, it seems, yeah, that's a good question. I see that as a line drawing exercise, more or less, like with civilians. Line drawing in this sense. Look, I could kill this entire battalion of enemy soldiers, and doing so would save one of our lives. Or I could kill just a few of them, but one more of our side would die. There it seems to me that military necessity, even though the legal doctrine of military necessity would say I can treat saving that one life as a military necessity, I don't think morality permits that. I should mention that even the legal doctrine about that is changing. At the end of World War II, the Nuremberg courts laid down a standard for military necessity, which is roughly that anything that saves you any risk or any money or any time at all, provided that it's otherwise lawful, you can rack up as military necessity, which seems to me crazy because it confuses military convenience with military necessity. The more recent legal developments have been something that's more like a balancing test. Here, an example that I'll give, which is a decision that the Israeli Supreme Court made in a case called Beit Surik, which was about the location of the barrier that Israel built, which was litigated one section at a time about whether the suffering that it inflicted on the Palestinians in the area was proportionate to the security balance. In Beit Surik, they considered one section in which the court accepted the military commander's claim that there was no alternative location that would provide as much security. And the court said, too bad. The suffering that you are inflicting by it is so much greater than your marginal gain in security that it's disproportionate. So that's a very different way of thinking about it. that says that before you can count something as military necessity, that there is a disguised proportionality judgment in it. It's a huge move away from that World War II, post-World War II test, which says anything that saves you, spares you any risk, any money, or any time is a necessity. And so I would go with the more, with necessity grounded in proportionality instead.
Professor Berger for a second round. The microphone can.
Thanks. So your discussion in the paper of the second point on the whether or not there's a different degree of care for own or other citizen, I found really humane, really compelling, and convincing. There's this one point that I did pause on, and I wanted to just hear a little more on it. And it's when you were working with the allegation or the kind of metaphor between family and citizen. And you were talking about the Frank Richards situation and making the distinction between the permissible and the required. And in that example, you said if as a matter of, if I understand it correctly, you say as a matter of morality, he could permissibly go to extraordinary or subordinate or heroic sorts of ends if he suspected his children were in those cellars. But that was purely a matter of permissibility, not moral requirement. And I wasn't entirely certain about that. Would that the intuition on what we think was the moral requirement in the case of family? So this is a little bit off the kind of stream of the whole argument, but that actually in the case of family, that our moral sense of the minimum requirement actually doesn't shift. So do we have the same moral expectation with Richard's qua father, right, going into this setting as we do with combatant or non-combatant, forgetting about the citizen, non-citizen?
Okay. I would answer that by distinguishing, as I think you just did, between Richard's qua father and what obligations parenthood imposes on him, and Richard's qua soldier, and ask what obligation soldierhood imposes on him. I'm suggesting that there's always some minimum level of risk-taking that soldierhood imposes on him. And he can go above that if he wants. Now, it might be that it's morally obligatory for a father to go above that for his own child. Okay, but the source of that comes from the obligations of parenthood, not the obligations of the soldier. So here's the kind of situation that I have in mind is this. Even if you're not talking about the enemy civilians, there is a real question about how much risk military people take for their own civilians. Think of a situation in which gangsters have taken a bunch of hostages, and for some reason, I'll just make this up, it's the army rather than the police, which might have a different ethical view, who's sent in to rescue them. It might be that the army has to take some risks to minimize the number of hostages that get killed. They can't just forget about the lives of the hostages completely. I mean, you might remember this incident from, I think it was 2002, in which a Chechen militant group seized the Moscow theater. And the way that the Russian forces responded was to pump an anesthetic gas in to put everybody to sleep, and then they came in and basically blew the heads off of all of the militants. But in the course of pumping the poison gas in, they also managed to kill about half of the hostages because it was really toxic gas, and it seemed as if this was soldiers who decided, our own civilians, forget them. We're holding our own risk down, and if we kill half, never mind the atrocity with them, just shooting the unconscious terrorists. They claimed that it was because they had suicide vests and there couldn't be any chance. But let's not get into the facts. That was an example of soldiers deciding not to take much risk for themselves, even to spare their own civilians. So I'm supposing that there is some minimum risk that soldiers would take for their own civilians. And my argument is you could take more. It's permitted for you to take more, even selectively, but you can't take less for anybody. Now, just to return to your question, and it might be that as a parent I would be obligated to take more if it were my own child.
And
Okay.
so then you're tacitly sort of, and what you're rejecting then is that there would be a requirement to take more as a co-citizen. You're saying that that just doesn't inhere. Because if you're willing to say the
Yeah.
soldier plus the father can produce a higher minimum,
Right, I think
you're
that
really
would just,
saying that
I think that just begs the question.
Yeah.
Yeah.
Yeah, fair enough.
I'll take two last questions.
You had your hand?
Madam, yes.
Yeah, I'm not too sure how much you've answered this question, but you've drawn a fine line between the armed soldier and the unarmed civilian, or the civilian who is armed yet not trained to use it. And I'm trying to force in a third party that is armed, very highly trained, and it's the private security contractor. So I'm talking about the Iraqi context. We've heard about Blackwater. And actually this morning I heard that the Iraqi government has enough information to say that 90% of the assassinations taking place in Iraq right now are committed by private security contractors, foreign, therefore American. And there are around 100,000 of them armed and highly trained in Iraq right now. So how do these guys fit into this equation? So you're talking about the armed soldier in terms of morality. And how much risk can these guys use for self-defense, and how morally obligated is an American soldier towards the American private security contractor and the Iraqi civilian who he is obligated towards because of the agreement that they've signed with Iraq? So how does this all fit in together? To
me, the moral principles that apply to soldiers apply to anybody who is doing the same function as the soldier. So the nature of the contractual relation, whether this is somebody who's enlisted in the Army or whether they are outsourced, whether the military function's been outsourced, whether they're a mercenary, is irrelevant. So I think that they have the same moral obligations that soldiers do, and that means to take risks in order to minimize civilian casualties. Now, the real problems are that they don't. In actuality, they don't. Now, I mean, this is a real seamy side of the private military contractor. I'll call it a scam, because part of the reason that private military contractors have been used is we talked about casualty aversion in the public. One way to hold down the casualties is to note that as a psychological fact, the American public, I don't know if this is true in Canada as well, hear casualties, they think are soldiers. So just hire up a bunch of people to do some military operations, and if they get killed, they don't get recorded as our soldiers' casualties, and the government looks better. It was also a way to keep down the reported total costs of the war. A lot of the military contractors their contracts went through the Department of the Interior rather than the Department of Defense, because that went on a different line of the budget than the war, so it makes the war look cheaper. The rules, the rules of war crimes. You don't want your own people. You want your own troops committing war crimes. So hire Blackwater and then prosecute them or not. As it turned out, there were a bunch of legal loopholes, which I actually think weren't intentional, that they were just poor drafting of statutes that allowed the Blackwater contractors to escape liability. And another thing is that you can, when you said foreign contractors, meaning Americans, actually the American companies hire contractors from all over the world. And sometimes they do it precisely because they're trying to make sure that it isn't Americans who are involved in this seamy stuff. So where is it? where is military contracting? I mean, it sounds like I'm just saying, let's just get rid of this practice. It makes sense in certain things. It makes sense, for example, if you have a fancy computer on the battlefield, to hire somebody from the computer company to service it. Why require that a soldier be trained to do that when they don't know as much? Or, you know, to get some restaurant company to provide the food rather than having the military cook it themselves. But when they're taking over combat operations, I think that that doing this through private contractors is one of the great evils that we have right now. It may be a necessary evil in some places. You know, the one other uncomfortable fact about private security contractors, aka mercenaries, is that humanitarian groups all over the world who are doing refugee work, for example, have to hire them because they're going into the most dangerous places in the world and nobody else is protecting the United Nations High Commissioner on Refugees. Hopefully they're not hiring Blackwater, but they're hiring somebody who does just what Blackwater does. But just to repeat my basic point, it is the ethical principles are the same regardless of which side of the public-private divide the individual finds herself or himself on.
One last question. Mister, if you can take that microphone.
Oh.
Thank you.
I think it'll be a quick question. So I believe you mentioned that innocent civilians on both sides should be considered equal and you shouldn't have preferential treatment for one or the other. Is that correct? So what about a situation, and you also mentioned that a state or an entity has the moral obligation to sort of diminish the casualties of its actions, right? So if it's causing damage, it should limit the innocence of that damage. So what happens when you're defending? So there is an aggressor that's attacking your innocent civilians, and the only way to stop it is by causing collateral damage to innocent civilians on the other side. Is there a justification there? So meaning that your innocent civilians, in this case, would be valued higher than the ones on the other side because they're the aggressor.
Yeah, so I think that if the situation is that the only way to repel the aggression or other unjust warfare is to cause civilian casualties on the other side, then your obligation is simply to minimize them. The fewest civilian casualties, unintended civilian casualties on the other side that you possibly can, and still repel the aggression. So I don't see that as weighing the lives of our civilians against theirs directly. It's if you've got, maybe this is a place that the jus ad bellum is the right question to ask. If you have a just cause of war, then you're permitted to fight it, and then the jus in bello requirement of minimizing civilian casualties on the other side kicks in.
On this note, please join me in thanking Professor Luban and Professor Priel. Very thoughtful discussion. Thank you very much.